you want to go for it?
We're very prepared, as you can tell.
Yeah.
One of the key qualities that we're meant to be talking to you about today. So that was actually quite a good summary. You have got a bit of a spectrum sat in front of you. And I get that for a lot of you, you might not study family law, or if you do, you sort of shoehorn it into a module. Say from the outset, that is not necessarily a problem. A lot of us, when we start out, haven't actually studied it before, and it's really an area where you get to learn on your feet quite literally, which is one of the reasons that I like it so much. But if you're thinking about a spectrum of it, you have sort of finances on divorce, sort of one area. You've got the private children work, so disputes between two parents, and then you have the public children side of it, which is what Mark does more of and I do absolutely none of, which is when you have local authorities and care proceedings that have been instituted. So there's a really broad church that family law covers, and I think it's pretty fair to say we're getting more specialised now
that's right.
than it perhaps used
Definitely.
to be. So as I said, I don't do any care work, and my set mostly does the finance side of it, although at the beginning of the junior end you do a bit of private children work as well. This is very informal from us. That was sort of a bit of a broad overview, and we're meant to be talking to you today really about why we got into it and sort of what qualities and skills we think you should try to bring out if you're thinking of going to the family bar. Mark, I'll let you say why you got into it.
Thanks, Alex, for that. I mean, Alex is right in terms of how specialised the area has become now, within the area, has become now. I wouldn't for a moment want to tread on Alex's toes in finances, and I'm sure perhaps the other way around in terms of public, because the statutory instrument, case law, procedure are so different and increasingly specialised. What I would say, though, is to keep your options open at the beginning. And I think that was something, as Alex has touched on, coming through university and studying family law, be evident to you that covers a huge range from perhaps divorce and the finances at one end, through the private law children, public law children, and also surrogacy, adoption. Lots of different areas of interest where you can show different skills, written work, court advocacy, maths and calculations.
Yes.
On your side, in all areas, I suppose, and this is common to them, and this is coming on to why I wanted to do this sort of work in the first place. Common to all the areas I've just mentioned and Alex has mentioned is dealing with people under very difficult circumstances in their lives. We're not just talking about whether a contract was breached or whether a company shares should or shouldn't have been passed to people. We're talking about crucial things in people's life. A divorce, how they're going to afford their life after a divorce, how much money they should get, what are they going to have in their pocket next month, is their child able to live with them, stay with them at all, can they have any contact with that child, is their child going to be adopted, and are they never going to see them again? So why did I choose this particular area, and then why I chose the relevant area of practice, is because I think you are dealing with people in a sort of visceral sort of way, and that suits some people and doesn't suit others. In the public law work I do, and I specialise now in traumatic brain injury cases in particular, small children, as you can imagine, all of those involve not only the parents but those who are investigated, it, social workers, guardians and others, are at a very heightened stage of emotion throughout that process, and it's a privilege to represent people when they're under those most difficult of pressures. So that's the reason I chose it. When I started at the bar, I was all dead set keen on being rump-hole of the Bailey. I'm about the same size now, but other than that, no other likeness. Crime just wasn't for me. That's not where my skills sat. And after a few years, I moved into family and found that that was something A, I was passionate about doing, and B, I had the skills to do. So again, keep an open mind when you're starting about any areas you want to move into. Alex, I don't know whether, in terms of you starting out, was it something you were sort of mad keen on, or how did you find yourself going the way that you went?
Well, I sort of fell into it. I had a
Sure.
friend at law school who was very set on family law, and I was sort of trying different areas, and she sort of pulled me aside and said, look, this might be something that you might be interested in, you know, go and have a go and do a mini. And I think, touching on what Mark said, you know, no one ever thinks they're going to end up in the family court. That's how I tend to explain it. So you are dealing with people for whom it might well be one of their worst days that you meet them. And the nature of work at the bar is that, you know, unless you've had a conference with them beforehand, sometimes you meet them for the first time at court. And it can be really disorienting for them because you're parachuted in, you know, particularly emotively if you're dealing with a children case, and you're standing up and you're saying, well, let me give you advice about what's in the best interest of your child. Let me give you advice about what the court might think is in the best interest of your child, and then let me go and tell the judge that. And, you know, that kind of disconnect that some people can feel when they turn up at the family court is quite hard to manage sometimes. And you've really got to have an eye to client care in a way that you perhaps wouldn't have to do in other areas of law. Now, that's not for everyone, and it can make your days really quite fraught sometimes, but on balance, the payoff of the sort of rewarding feeling you get from that, I think, was something that did draw me to it. To be a bit more flippant, I'm also quite nosy. And you open your papers and you get this snapshot of somebody's life and what they're going through at that particular point in time, and then, you know, you can't fix everything, but you can go in and you can help. And that side of it keeps you interested and motivated day to day, because you will be working quite hard sometimes. I mean, I will be in court probably much less than you, perhaps. I mean, I'm sort of average 3 times a week at the moment, but I'm at the very junior end. I'm sort of I'm in my second year of tenancy, so that will decrease the sort of longer on I go. And finance work, you are just in court less. There's more gearing towards trying to settle it, and that means necessarily fewer days in court. But when you are starting out, you do get those sort of 3 times a week on average days. And one of the things that drew me to it was I was looking at perhaps commercial side of it, or sort of other areas and less crime, was the fact that you get the balance of actually being able to be in court a reasonable amount when you're junior, and you actually get to do advocacy in a way that perhaps in other areas you don't get as much opportunity to do.
Yeah, that's right.
And a lot of it's oral advocacy as well. And again, that's not for everyone. You know, there is a really broad church of areas of practice at the bar, and figuring out which bits of the job you like doing and which you don't can help guide you towards areas of law. And that sort of was one of the things that really drew me to it, is the nosiness. It's being in court a reasonable amount, and, you know, on a slightly more personal level, it can be very rewarding when it goes well. You have to flag that if it goes badly, you sort of feel the, I hesitate to use the word losses, because it's not meant to be so adversarial, but you feel those slightly more keenly, and you very much have a human client in front of you who feels them extremely keenly, and you have to learn to be quite resilient quite quickly, not to take on all of that, because otherwise it would be a less enjoyable job than perhaps I find it. But I would definitely recommend it as an area of law, clearly.
I suppose that brings us on neatly. I'm just looking down at the bullet points about the lifestyle implications of practice, and I think, Alex, you touched on them, haven't you? And I think I'm in court every day, and it's an advocacy based, as Alex was saying, a focus on settling and saving money and making sure there's more in the pot than there might be if things fight to the end, is a perennial in financial remedies proceedings. But in public law, often, sadly, those matters have to be dealt with in front of the judge and hearing the evidence, not only on fact find but at the welfare stage. So I'm in court a great deal more. But I think certainly from starting, I don't know, Alex, if you agree with this, but certainly in terms of lifestyle implication, it's probably for most areas of the bar as well, when you're starting, short notice.
Yes.
Being told at 5 o'clock by the clerks, this has just come in, somebody has heard, so here are the papers for tomorrow. That doesn't happen anymore, of course. It comes in an email that plops into your inbox, and there might be 1,000 pages, there might be 3,000 pages, and you've got to be ready tomorrow, because when the judge sees you tomorrow, on that case, you're representing Mrs. Smith, Mr. Smith, whoever it might be, and the judge is you're their advocate. You've got to be there to answer any questions. You've got to be there to deal with it. So certainly when you're starting, and I think throughout to a certain extent, there are times when any plans you might have had go massively out of the window, because sometimes you've just got to pull the all-nighter to be ready for the next day. Now that's not exclusive to family, of course. There are plenty of other areas, but you guys, none of you would be here if you hadn't worked hard already. I'm looking out at you. And I've said to a few people I've spoken to this morning, you've already had success. You look round at a day like this and see, there's hundreds of people. Oh my goodness, how imposter syndrome. How am I going to make it? How am I going to get to what I want to do? Well, look back as well as looking forward. You've all had success to get where you are now, and it's not easy. It's hard, and it remains hard, but it's easy hard because, as Alex said, you want to do it. Yeah, she's nosy, I'm nosy. You open the papers up, and from throughout. I've been doing it 30 years. Alex has been doing it a couple. But I tell you what, it never ends. You open the papers and think, oh my God, that's outrageous. Wait till next week. You open the papers again. There's something even more outrageous they've done. And families are we're all in families, aren't we? So we know what people sadly can do. But that's A, the interest, and B, I think sometimes the lifestyle. It is difficult sometimes to manage, and I think I don't know about you, Alex, but I think that's something you've got to learn quick about managing it with the clerks, isn't it? How do you find that?
Well, I'm at the very junior end, and so I tell this joke, and it is very flippant, but the clerks say jump and I say how high, and that is the reality, mainly because when you're starting out and building a practice, you don't have a reputation, you're part of a chambers, and the clerks are wonderful in effectively helping you manage starting out in those early years and getting work. And so of course you say yes, and you eventually reach a point where you say, okay, well now I know where my limit is. And once you work that out, occasionally, very occasionally, you can draw a line and say, okay, then that's actually something that I can't do. But that's something that when you start out, you very much have to learn as you go along how to deal with it. And as Mark said, there are last minute hearings in family law, there are urgent applications, that is the nature of the work that we do. And I remember something that a law school teacher told me once that really stuck with me, which was sometimes advocacy is about being the duck. You're gliding across the surface and no one can see that you're frantically paddling underneath the surface of the water, but it's all about making sure that however much frantic paddling you're doing, it's just sort of smooth surface. And sometimes very late at night I do have to think to myself, be the duck. It helps. But what I was saying earlier about the sort of real human element to family law does also help with the last minute element, because if you have that extra motivation, it's not just you're going to be in front of a judge tomorrow and so you better be accountable for what you're saying. It's you've actually got a human client who is relying on you being accountable for what you're saying and actually really knowing it inside and out, and that can help when it's all very last minute and when you're sort of rushing off and papers are flying everywhere or emails are pinging around, I suppose is the modern way of it. And that is one of the reasons I think that family law, from a lifestyle perspective, when it does get hard, and a lot of areas of the bar will get hard, I like the fact that I've got that additional motivation. It gives you that bit of a kick, really, and just sort of helps you get on with it because you've got a human at the other end of it at the end of the day. I think the other real lifestyle implication that I've found is that, and again, this is not solely applicable to family law, is that obviously you're self-employed, you've heard all of that before with the bar, and so
it can be isolating as a profession. That's something to sort of flag at the outset. But what I find about the family bar in particular is because there is a collaborative sense of family law. You know, we're not a retrospective profession. We're not trying to work out, going hell for leather, who breached the contract, or, you know, who committed the crime, or whatever. You know, you're dealing with a family, and you go away at the end of the day, and that family is still there in some shape or form, and they have to get on with their lives. So that sort of collaborative element to it, that attempting to try and settle, see if you can reach some kind of agreement because it's better for everyone at the end of the day, transfers into the profession. You know, a lot of us are quite collaborative minded, even though we're all self-employed, and so you actually find that you have wonderful colleagues, you have wonderful friends at the bar, who you're working opposite quite a lot, and having that element of trying to have a working relationship where you negotiate and agree with whoever is on the other side makes your day again that little bit easier, because you're self-employed but you've got someone else there, and you can get some real rewarding professional relationships out of it as well.
I think that's a really important point, and I think that's the little I know about other areas. I think that is something that we're uniquely perhaps proud of, actually, in terms of the family, like the Family Bar Association, for example. And I think Alex is absolutely right. Colleagues are incredibly important. Certainly in public law, family work, when it gets relatively rarefied, it's the same faces that you see doing a 10-day case in Carlisle as you see doing 15 days in Plymouth. It's a national group of, and Alex will find this, as you get more and more specialised even in financial remedies, there's the go-to people, and there's a group of real specialists in an area, and those people do work collaboratively. When you're in court, you're putting different arguments. That doesn't mean that when you're not in court, you don't take that outside. And it's very much frowned on if people are doing the sort of what we would describe as robing room advocacy, that when you're outside the courtroom that you're trying to put pressure on. I put that in quotation marks. I've certainly not. It's different from the 80s, perhaps, but that just doesn't happen in family, and I think we do have more of a handle rightly on well-being, not only in terms of the work schedule that we give ourselves, and chambers give us, and our solicitors give us, and our clerks give us, as Alex has touched on, but also with colleagues. I think we probably to a certain extent touched on this, but I think the last sort of bullet point, really, key skills and personal qualities. I think we talked about, I suppose, things that you'd have to say in any area of the bar that I've already mentioned to you guys. You know, hard work. You know about hard work. That's not going to come as any surprise to you. Personal qualities in family. I think Alex has really touched on it already, but I would certainly use the word empathy. Really, you know, having an understanding. Even when even when, it's often sadly the case where you've got to give what your particular client sees as bad news. That's difficult to give to anybody, but if it's realistically where your view of the evidence and the way the court might approach it, whether that's in terms of family remedies or whether it's in terms of what contact a client might get in a private law dispute, or what the court's likely to do about a local authority's public law care application, that's difficult to do. It's difficult to do in a way that understands, and as I say, we're not telling a company's CEO that share sale didn't go quite so well. You're telling somebody that I think the evidence suggests to me that the court is likely to say that your son should be adopted, and you're not going to have any contact with him ever again. You've got to have an understanding of how people are going to react to that, and as Alex has already said, I keep repeating what Alex has said because she said it already, but that telling people things like that is difficult, and it's not going to suit everybody. It is the truth. So I think having empathy, wanting to deal with human situations. I spoke to a lady this morning who's clearly an expert in surrogacy. It's something she'd done in a master's to a very high level. You get a niche area like that, you're going to be dealing with people who, even outside of court, in advising them, is this an arrangement we could do? Are we going to be able to have a baby like this? other examples, we do cohabitation matters. Am I going to be left with nothing after living with somebody for 20 years despite we're not married? Well, I'm afraid. So it's difficult, and having those having that empathy to do it is important. I mean, is there anything else you could think of particularly, Alex, which you...
Well, it sort of goes hand in hand with empathy, but it's that sort of classic concept that understanding something well is being able to put complicated concepts simply. And I mean, I'm leaning here on the sort of finance side of things, but we have a number of concepts in the financial remedies sphere that we sort of rely on acronyms and impenetrable language, but the reality is you're going to have to be explained to a human being, sometimes in very short order, something that you understand and that is dressed up in a lot of technical terms in a very straightforward and plain way. And being able to do that, I think, is, when you're under time pressure at court, is another skill. Again, you don't have to be perfect when you start, but you have to develop as you go along. But just having a sense that that's something you might want to work towards is I think, helpful. Yeah. On the finance side of things, can you add up columns in Excel? Make sure that you can. We will joke sometimes that financial remedies law is simple. It's add up and divide by 2, or is there any reason not to add up and divide by 2? But the adding up point is actually quite important. So perhaps if what we've spoken about in terms of the empathy and the human interest element really appeals to you, but your maths isn't fantastic, you might want to look at the other side of it, and these sort of other areas of family law than the finance work. I mean, I think we've broadly touched on everything, because a lot of the skills that you'll be told at these types of talks are quite common to all areas of the bar, the hard work, etc. For the family side of things in particular, just that little bit of resilience goes a long way. It's quite difficult in your early years of practice to learn how not to take on the load of your clients, because we've said, you need to have empathy, and you do. You cannot be a robot doing this job. But where that can be a bit of an Achilles heel is having too much.
Yeah.
And being able to balance that and being able to sort of switch off at the end of the day. Mark touched on wellbeing. It's a hot topic at the family bar at the moment. A lot of the stuff that we do can be difficult, it can be emotionally draining, and we'll go hell for leather in the early years of practice, trying to learn as much as we can and do as many cases as we can. Being able to take a breath and just sort of switch off can go a long way, I would say.
I suppose also, I mean, this is interesting for me really, Alex. You talked about, the last sort of couple of 3 years, that's sort of throughout the COVID period, you've been sort of starting.
Yes.
Which must have been actually pretty difficult, actually. Remote hearings and dealing with people remotely. I know from dealing with, and certainly back in March, April, May of 20, doing a number of lengthy hearings, which was new to all of us, contested public law hearings remotely. And they were very difficult to do, because being able to be empathetic to your client, who wasn't, some of these small rooms in courts aren't great, but you weren't in a small room across a desk from them and looking them directly in the eye and saying, oh dear. You were having to do that on a telephone line or down a screen. That was actually a difficult skill as well. I'm just noticing, lastly, in brackets, Alex, here, any personal qualities that would make it very hard to succeed. Well, none of those apply to us, of course, because we've both succeeded. So it's difficult perhaps to answer that. But no, joking aside, I think not dealing with people in a sort of too hard-nosed a way, too commercial a way, if I could put it like that, that wouldn't be something that would help you in this particular area. As Alex has said, sometimes there are very complicated things that you need to simplify and explain. But to simply say to a family client, well, that's the way it is, so there it is, would not be a good way of dealing with it.
Well, I suppose it depends on the sort of case. I mean, I'm thinking in terms of the finance side. Obviously, the more senior you get, the broader the asset base is that you're dealing with, and perhaps you might be dealing with someone who's been very successful in whatever business field that they're in, who actually sometimes does appreciate a bit of very hard work, you know.
True.
So there's a lot of variability to the work that we do, but if you've got to have a bit of an ability to read people, because you have to pitch it. So, you know, talking about personal qualities that will make it very hard to succeed. Ultimately, if you couldn't read a room effectively, I think that's probably going to make it quite difficult for you, because you do have to work out how to pitch what you're saying, what approach to take, and what is making the person in front of you tick. Because certain people will have, I mean, I'm speaking from the finance side of things here. You can, you know, talk until you're blue in the face about how a court's going to approach something when you're at a settlement hearing, and you can be told by your client, you know, no. And sometimes there is one particular thing that is driving that, and actually if you rejig the way that you frame what you're suggesting would be an appropriate offer, and one particular pressure point comes out, suddenly everything's great. And you can have those sort of magic moments, as it were, where you work out where the pressure points are and you actually work around them. But you've got to be able to do that first step. And being able to pitch the advice that you're giving and the way that you're giving it is quite key. I'm not claiming to have worked that out yet. As I said, I'm very junior, but it's something that you sort of have to be thinking about and trying to develop.
And I also think that's a very, very good point. Possibly less so in financial remedies, although this would certainly come up, but certainly sadly, because of the type of client you're often getting within public law children work, there will be mental health problems, there'll be learning deficits, and again, so that skill about pitching, how you're communicating to somebody, I suppose it applies to any conversation in life about anything, doesn't it? But that is a very particular skill, I think, in family that you're always learning about, actually. I think if somebody told you, well, they know they can do it every time, they're lying. It is difficult.
Well, I think we've run through the nice handy bullet points that we were given to talk to you about. As you can see, we're prepared. But I suppose it's sort of now over to you. I know you've all had the opportunity to go around the stalls, or maybe some of you haven't yet. I can certainly see some people that I've been speaking to. But if there are any questions that you guys have, I think now's probably a good time.
Yeah, just had a question on, do you have any tips on how do you get through bundles so quickly, especially when you're doing something the night before or a couple of days before you're having it the next day? How do you absorb information?
If someone could give me the answer to that, I would be really grateful. I mean, look, a lot of the stuff that you get, it is a good question. A lot of the stuff that you get through, you have sort of court application forms, for example, and you will learn the format of those quite quickly. When you start, everything is, oh gosh, I'm being confronted with this pile of paper. Whereas the reality is you'll have a brief, you'll know for the type of hearing that you're doing or application what's likely to be the most important bits to look at. I mean, I am out of an abundance of caution of the ilk that really likes to have read everything. If I've not been sent the underlying financial disclosure in finance cases, I want it. But equally, a lot of those pages will be pages of bank statements and disclosure. So if you're told we're not concerned about this being a non-disclosure case, and you say, okay, well, I can skim over the bank statements unless something's really crucial. So you get a sense, you start to know the more you do what to prioritise looking at. It doesn't change that. I mean, I still get a sort of slight feeling of dread if I'm doing a last-minute hearing, opening the papers. Is it going to be a 60-page bundle or is it going to be a 600-page bundle? What am I dealing with here? And you just have to become very comfortable quite quickly in prioritising what you look at and what you don't, and filling in your gaps.
And I think the orders that are made, both in financial remedies and in public law, but also in private law, or if you were doing a COT case or anything like that, there are now standard templates effectively for the orders. So I tend to go, yes, there's the brief, which is not always as comprehensive as you'd like it from the solicitors. Sometimes it's you're representing Mr. Smith and it's at 10:30 tomorrow, which is not terribly helpful. Often, I'm joking really, it's far more detailed than that. Go to the last order. The last order will say will have what the parties' position, in public law anyway, it will set out what the parties' positions are. The local authority wanted X, Y and Z, mother agreed or disagreed or whatever, father, guardian. You know what's been ordered on the last occasion, and then the listing will often say the issues for this hearing are A, B, C, D and E, or bullet points, whatever that might be. Now in public law, I'm seeing sighing from the other side here. In public law, you often know, is this a further case management hearing where the court's got to decide, should this person be a witness, should that person be an intervener? And you can narrow it down, so you know you're not having to look at, this isn't going to be a contested hearing with evidence, let's say, but I'm going to have to work out what our position is and what my arguments are on, there's a re-W hearing, which is, should a child give evidence? Or do we need this expert? Should it be that expert? Is it timetabling? So you go to that and you know this hearing has got a time estimate of X and the issues to be dealt with are A, B and C. So that would narrow down. Often also, fortunately in public law cases, I don't represent local authorities, but local authorities, the local authority case summary, which is sent to the judge a number of days before the hearing, will often say, would give the judge a recommended reading list. Mm-hmm. The first social work statement or the third social work statement or this expert's report and then the guardian's analysis, and that will pick out, you can say, well that's helpful, boom, 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 right, I know where I am, and then you know what more you've got to read. But yes, you always get that daunting feeling when the email comes, oh my God, look at the index bundle, is 1,000 pages. Often, at short notice, not always, sometimes it's a lot worse than that, but often it's because there's something relatively short to be dealt with and you can really focus. I mean, is it set out like that in financial remedies? It's not, no. Right, okay.
No, but I mean, equally though, financial remedies are sort of the shape of a standard case is 3 hearings, first appointment, FDR, which is the negotiation hearing, then a final hearing. Yeah. Now the orders, we're told in finances, we shouldn't be setting out so-and-so's recitals contentious, don't darn a hill over them, and they're generally kept quite short. So you've got to look at other places, but again, you'll have Forms E disclosure, so the sort of standard disclosure format that you give your financial disclosure and that sort of should give you a sense of what's going on, at least on the face of them. And then we have other sort of new practice documents for the Financial Remedies Court that theoretically should give you a sort of steer as to where you should be looking. I mean, our sort of short notice applications will be freezing injunctions, or you're covering something last minute. And again, those, whilst they can be daunting to get on top of again, it'll be a sort of, this is the application that's being made and this is why it's being made at short notice, or sometimes without notice. So you have your already, you're dealing with a discrete point rather than the whole case. And then hopefully you shouldn't be getting instructed last minute for the trial, unless you're covering at last minute, sort of short notice for somebody else. But again, we don't have that kind of a nice template format would be very lovely in certain cases, but equally, as I said, you get used to knowing where to look and prioritising. And I'm still learning how to do that, and you'll learn a bit with each case. That's the benefit of this career.
Thank you. Anyone else? Yes, please.
With all the hearings that you do, so do you get to stick with the same family that you're working with, or do you get called away last moment? Like, when you're working with relationships with your clients, can it be that you suddenly get taken away from a case?
It's difficult. Yeah. Everyone's diary is, well, I say everyone's, fortunately, is quite busy, and of course you can't do every case. So if you're doing something and then that gets listed for a time when you've already got something else in the diary, I'm afraid you can't do it because you're committed to that case. Well, often there are obviously times when it changes, but effectively you're committed to something else. And in public law cases, and they're listed quite a distance away usually, one can usually juggle these things, but I'm afraid, sadly, continuity is a continual bugbear in family, not only because ideally it should be the same judge, because they've then got a handle on what's happened. That's slightly different in financial remedies because of the FDR system, but certainly in public law hearings, the case is allocated to Her Honour Judge blank. but that doesn't always work because the judge is dealing with something else. So that's a perennial problem, and for barristers as well. You've represented the mother throughout, and then the final hearing gets listed and you can't do it. It's very, very difficult, and that probably, I suppose, comes into where the collegiate element of the family bar, then you'll need to hand it over properly to somebody rather than just say, well, there's the papers, you're representing Mrs. Smith. You need to have a proper chat with her. I've represented Mrs. Smith throughout, and she's like this, and she's really worried about that, and you hand it over. But continuity, is a massive problem.
Yeah.
Anyone else? Sorry.
So I appreciate that you don't need the detailed knowledge of family law when you apply for pupillage, but I suppose, do you guys have any tips in terms of how you can get more knowledge and develop skills for the bar course or any stage of university education?
I suppose I was applying far more recently than
Don't rub it in.
Family Law Week is a very good website. It's got some good summaries on there. Often if you sort of Google a case, it's one of the first places that comes up. I would look on there and they have an email alert that can go off. I mean, that's quite tough because obviously you're jumping in at the deep end with sort of ongoing cases, but they would have some good articles on there as well. We've just got a newly launched journal, the Financial Remedies Journal, on the finance side, that's got a website on there, sort of case summaries, articles. Again, that's good towards practitioners, but if you want to get a sense of what the topics are that people are looking at or talking about, that's quite a good place to start. I am very much of the new generation ilk. Twitter I actually find useful professionally. I don't really tend to tweet, but there are a couple of good accounts on there that effectively tweet out cases and updates and opinions, and that's actually quite a good way of keeping on top of things, sort of as they're coming out. Particularly, I'm very much a social media generation person. It suits the way that I think. But I mean, it is difficult because as a way in, we tend to be quite densely focused on certain topics that we also claim to have big background knowledge in. But reading those as a starting point, I think, is helpful because it just gives you a sense of what are the topics that people are interested in at the moment. So, transparency being a big one.
Yeah.
I think the backlog of the court system, the
Yeah.
overloading judicial continuity being another one. People will be writing articles on those, and you can sort of get a window into them in a way that you perhaps wouldn't necessarily, because around the area otherwise do.
I think there's quite a lot, as you say. There's quite a lot out there. I mean, for example, I know the inns, the libraries at the inns. You can sign up for the email alerter. I've got it I've got it for a number of different things. But in a temple, for example, you get a daily email from them which has the news-related stories, law-related stories, reports that have come out on a very general basis. But that's just keeping you updated as well. But yeah, Family Law Week I think is an excellent place to start. That's entirely free.
Yeah.
Anyone else?
Sorry, I'm going to jump in.
Okay, no worries. No worries.
I just want to say a huge thank you for their time.
Thank you very much.